Parles-tu français? Hablas español? Parli italiano? If you've used Babbel, you would. Babbel's conversation-based techniques teaches you useful words and phrases to get you speaking quickly about the things you actually talk about in the real world. With lessons handcrafted by over 200 language experts and voiced by real native speakers, Babbel is like having a private tutor in your pocket. Start speaking with Babbel today. Get up to 55% off your Babbel subscription right now at babbel.com/Wondery. Spelled BABBEL.com/Wondery. Rules and restrictions may apply.
This was probably a lie, and that the government was looking to implement that February 18th memo that we discussed, and that meant getting D.V.D to show up somewhere in person so they could physically take him into custody, send him off to one of these ICE camps, and then rendition him to a third country, meaning El Salvador.
Which, by the way, is exactly what the Trump administration was planning. They don't dispute it in this case, and they have indeed been scooping up immigrants at these routine appointments and summarily deporting them. Welcome to Law and Chaos, where you get a TRO, and you get a TRO, and you get a preliminary injunction. It's another week of everyone suing the Trump administration and winning. We've got a lot to cover, so let's get after it. Happy Friday, Chaos Monkeys. I'm Liz Dye, and with me, as always, is Andrew Torres. Andrew, how are you?
Well, I looked under my seat, and I could not find either a TRO or a preliminary injunction, so I feel like I've been left out. But other than that, I'm great. How are you?
I'm doing all right. I had a really nice time with my friends at book club, so I'm good. What else is there?
I think maybe one or two things.
All right. Well, listen, breaking news. Andrew, have you heard the Trump administration gets sued a lot?
Does it really?
Yeah. Obviously, we're struggling to keep up with the craziness of every single news cycle and still cover important stories the way they should be covered.
Yeah, you can pry those deep dives from my cold, dead hands, Liz.
They can take your deep dives, but they will never take your freedom. No. Of course, we will still be doing deep dives, but right this minute, we might have to do more roundup format shows because everything's on fire all the time.
Yeah, okay. But if we rename the show The Pacer Files, I'm out, man. Okay. Yeah. But yes, look, like this is an administration that thrives on beating us all down and normalizing law breaking. So we have got to cover these stories. We've got to call them out.
Yeah. Okay, but we are going to start off with a fun one because last night, all the very online lawyers had a joint panic attack after the Justice Department mistakenly filed an internal memo trashing their own case on the public docket.
I literally felt the blood rush to my ears. It was great.
You and every attorney on BlueSky. This is the case over New York's congestion pricing, which Transportation Secretary Sean Duffy declared illegal 2 months ago. The program was approved by the Biden administration, and it's doing exactly what it's supposed to do. Car traffic is down, foot traffic is up, businesses are happy, and we can't have that. So Duffy has been screaming nasty threats and talking about how it's prejudiced against like white bankers to make them get murdered on the subway or something. And the state transportation authority sued the Department of Transportation, the federal Department of Transportation, seeking a declaratory judgment that the program is legal. Mm-hmm. And last night, the lawyers in that case, the Justice Department attorneys representing the Department of Transportation, mistakenly docketed an internal memo saying basically like, our theory of the case is crap. And Judge Lyman, the trial judge, is not going to go for this, and neither is any other court. And by the way, since you just pulled this decision to cancel congestion pricing out of your ass, there's no actual agency record to support your claim that it's based on something other than animus. So if you continue with this case, the plaintiffs are going to subpoena your comms and put you under oath, and you will not like that.
Oh, God, can you imagine the panic attack when these lawyers realized that they docketed that very candid internal memo instead of what they meant to do, which was Duffy's stupid latest threat letter to Governor Hochul? Okay, I actually have some sympathy, right? Because lawyers make mistakes when they file things all the time. So what normally happens in a situation like this, if you file something by accident, you say, oops, my bad, Judge. Can you just, strike the mistake from the docket? And like, that's what happens. It's just not that big a deal. And the DOJ duly asked for that relief here. But then, because this is Trump's Department of Justice, they put in some weasel words about, how the plaintiffs were definitely open to further discussions about striking the document. And turned out that was not entirely candid. And when you're going hat in hand to the court, candid is a better option. So this morning, two of the plaintiff intervenors, the Sierra Club and Riders Alliance, said that no, actually, they oppose striking the document and sealing it, since that document has now been widely disseminated to the public, thanks in some part to you and I. And what Judge Lyman said was that he wanted the parties to brief whether to strike the document from the docket, but also the question of waiver. And here's why. Because the document that they mistakenly included is absolutely relevant to this litigation. And now the plaintiffs know about it, right? So before it got out, there's a good argument that this kind of candid internal evaluation of the strengths and weaknesses of your case, right? Like, that's the kind of thing that is classic attorney work product, attorney-client communications. It's protected from disclosure by privilege. And it still very well may be, right? I don't mean to suggest that they've definitely waived it. But now, if it does get struck from the record, plaintiffs know about it so they can ask for this document in discovery.
Right. Or if they don't ask for this document, the document says you don't have any internal agency proof that you did this for any actually good reason. And so they're going to ask for your email. So, like, if the document gets struck, that doesn't mean that the plaintiffs, they were going to do it anyway. They were, like, one of the attorneys on this is Robbie Kaplan. She's a very good attorney.
She's okay.
Yeah, she was E. Jean Carroll's attorney. Like, I guarantee you she was going to ask for this before, but she's definitely going to ask for all of that internal comms now. Which clearly the only explanation for what happened here is that it was a conspiracy by the Justice Department, deep state, right?
Yeah.
Apparently, the three lawyers who put their names on this memo are now off the case and perhaps out of the Justice Department because the Department of Transportation thinks that the DOJ is trying to sabotage it. And so the case is being moved to Main Justice because apparently only Trump's former personal lawyer, Emile Beauvais, can be trusted to handle corruption these days. And by corruption, I don't mean corruption prosecution. I mean doing the corruption on behalf of the Trump administration.
Yeah, good help is hard to find. Look, the Trump organization just had to fire its lawyer, Bill Burke, because he dared to represent Harvard in its lawsuit against the government. We talked about that in the last show. Trump called that a conflict of interest, which is, one of those times where he accidentally told the truth, right? Because apparently Trump thinks his personal business interests and the interests of the United States of America are one and the same.
Yeah, you're killing me here. Okay, here is the statement put out by the Department of Transportation's spokestwerp, anonymously, of course. Sure. Did not want to put his name on it. He says, are SDNY lawyers on this case incompetent, or was this their attempt to resist? At the very least, it's legal malpractice. It's sad to see a premier legal organization continue to fall into such disgrace. SDNY's memo doesn't represent reality. Kathy Hochul's congestion pricing war against the working class was hastily approved by the Biden administration after Donald Trump was elected. Taxpayers already financed the highways that Hochul is now shutting down to the driving public, and there is no free alternative. This is unprecedented and illegal. If New York doesn't shut it down, the Department of Transportation is considering halting projects and funding for the state.
So, keep making those threats in public. Like, it's helping, definitely. Mm-hmm. And, Liz, since you bring up the Southern District of New York, I should point out that 3 more prosecutors have resigned in the fallout from the Eric Adams Thursday night massacre decision that we've talked about. Here's a little bit from their resignation letter, which was published by the New York Times. The department placed each of us on administrative leave, ostensibly to review our and the Southern District of New York U.S. Attorney Office's handling of the Eric Adams case. It is now clear that one of the preconditions you have placed on our returning to the office is that we must express regret and admit some wrongdoing by the office in connection with the refusal to move to dismiss this case. We will not confess wrongdoing when there was none. We've served under presidents of both parties, advancing their priorities while pursuing justice without fear or favor. Now, the department has decided that obedience supersedes all else, requiring us to abdicate our legal and ethical obligations in favor of directions from Washington. That is wrong. We will not abandon this principle to keep our jobs. We resign. Hear, hear.
Yeah, agree. And also, we're the last one out at the Justice Department. Please turn off the lights. I mean, part of the reason that screw-ups like this happen, honestly, is that the Trump administration has gutted that place. They've placed guys like Trump's crony Jay Clayton in charge of SDNY. And by the way, Clayton, he headed up the SEC the last go-round. He's a lawyer, and I think he's a smart guy. He has never been a prosecutor, state or federal. So, I mean, putting him in charge of the second biggest prosecution shop in the entire country is
What's the first biggest?
I think it's DC.
Yeah, I could be. I mean, look, SDNY is a high profile. Like, I would have thought it was 100%. Number one. But either way, guy who's never been a prosecutor should not be running.
Right. I mean, and he is indeed in charge. I mean, I thought that getting Danielle Sassoon out of there was supposed to. This is a rabbit trail too far. Yeah, but just to be clear, in defense of these lawyers who, I mean, they screwed this up. Maybe it was a paralegal, who the hell knows. But part of the problem is that there really has been a massive brain drain at the DOJ. And you have people working all hours. I mean, this thing was filed at 9:30 at night, which lawyers work at 9:30 at night. Okay. But like,
when are we recording the show, Liz?
I don't want to talk about what time it is. But if you have these people who are working the equivalent of 2 jobs, and maybe they're not even qualified for those jobs because of this brain drain, like, shit's going to happen.
Yeah, and don't forget that your supervisor is asking you to violate your oath of ethics all day long. I mean, look, but by the end of this nightmare, I predict that you will have Pam Bondi alone in her office prosecuting traffic violations. Like, there will be no one left.
I mean, at least it'll be something she's qualified for.
Yeah.
Okay. Up next, Trump's executive orders targeting law firms took a beating in 2 courts this week, as well as in Congress.
Yeah, right. We have talked about these executive orders. We've talked about the 4 law firms that have sued the Trump administration. And on Wednesday, there were hearings on preliminary injunctions in 2 of those cases. The Perkins Coie and Wilmer Hale suits, both firms already got temporary restraining orders, and it's clear they are both going to get the preliminary injunction. Judge Beryl Howell,
OFB, our favorite Beryl.
She lambasted the government's lawyer, Richard Lawson, who he had no information on how the executive order was going to be executed, right? What the Trump administration thinks it's getting from the law firms who capitulated, or even whether those capitulation agreements had been put in writing or just, written in ketchup on the wall of the 5th floor conference room over at Paul Weiss. And the Wilmer Hale hearing before Judge Richard Leon did not go much better. He said that the executive order was clearly retaliatory. So while there were no preliminary injunctions issued from the bench, it's not a mystery where these cases are going.
No. But speaking of the firms that capitulated, the Vichy bar, as it were,
Ooh.
Democrats in Congress have questions.
Yeah, a lot of questions. 91 pages of questions. Questions like, what did you promise to do in exchange for the repeal of the executive order that targets you? Was this agreement commemorated in writing? Can we see said agreement? What is your firm doing to ensure that it can effectively and ethically represent clients in actions involving the Trump administration or private actors supported by the president and his political allies?
Good
Where are
questions.
the pretzel monies? What are you doing to get the pretzel money? Right? But kidding aside, these letters use words like bribery and the Hobbs Act and our favorite, RICO.
Yeah, I think these firms may live to regret it if Dems take back the House in 2026. I mean, I think they can probably get away with blowing off a minority request for information, but congressional subpoenas are not optional.
Nope.
I mean, I think it will come out before then, whatever the written agreement that they have with the Trump administration, I think will, I think it'll get
if there
leaked.
is one.
If there is one, but whatever the communications around it, I think that as Judge Howell said, we'll have to wait for the FOIA suits, but that's going to come out. And I suspect those firms will look even worse than they do now, which is pretty bad.
Yeah.
Okay. As we front load the good news, Sarah Palin's still a loser.
Mm-hmm.
She sued the New York Times in 2021 over a story that mistakenly suggested that she incited the shooting of Congresswoman Gabby Giffords in 2017. That story was quickly retracted and corrected, but Palin sued and said she'd been grievously damaged.
Right. We talked to New York Times reporter David Enrich about his book Murder the Truth last month, episode 114, and he talked about how Palin's suit was basically a vehicle to try and challenge the New York Times v. Sullivan standard, right? The case that established a heightened standard for defamation for public figures. The Sullivan standard has been a major target of the right for a long time, although it's clear that if it were overturned, it would include networks like Fox that would be the ones to pay the price.
Right. So this was a retrial because of what I think most people agree was a screw up by Judge Jed Rakoff. Basically, he sent the case to the jury, right? That he held the trial. He sent the jury out to deliberate. And while the jury was deliberating, he announced, I'm dismissing this case because the plaintiffs have failed to state a claim. But just to kind of appeal proof it, I'm going to wait for the jury verdict. But the jurors got push notifications telling him about that ruling. They got them on their phones. And then when the case went to the Second Circuit, the appeals court said that that invalidated the verdict because maybe the jurors were influenced by the court saying that the case was garbage, which okay, fair.
Yeah, no argument there. Look, I just want to point out that Sarah Palin's lawyers did indeed try to use that appeal as an attack on the New York Times v. Sullivan standard, right? As well as the underlying verdict. And the Second Circuit, right, in talking about the specifics of the case was like, fine. But with respect to the Sullivan stuff was like, get out of here with that noise. So I don't know. Maybe the right wing will want to give, changing the libel laws another try with this second trial. But, maybe they will just go looking for the next case instead.
Yeah, as will we. Right after this brief ad break, unless you are a subscriber at patreon.com/lawandchaospod or at lawandchaospod.com, in which case there will be no ads for you.
I earned my degree online at Arizona State University. I chose to get my degree at ASU because I knew that I'd get a quality education, they were recognized for excellence, and that I would be prepared for the workforce upon graduating. To be associated with ASU, both as a student and alum, it makes me extremely proud, and having experienced the program, I know now that I'm set up for success. Learn more at asuonline.asu.edu.
And we are back. Okay, this next case is kind of deja vu for me personally because one of the first cases I wrote about as a professional writer was County of Santa Clara v. Trump, a 2017 challenge to Trump's effort to withhold federal funds to punish sanctuary cities. That was enjoined by U.S. District Judge William Orrick of the Northern District of California. And I'm going to read you this order that he wrote on Friday, or just the beginning of it. It says, in 2017, President Donald Trump issued Executive Order 13768 titled Enhancing Public Safety in the Interior of the United States, which was directed at so-called sanctuary jurisdictions. The city and county of San Francisco and the county of Santa Clara sued, arguing that Section 9 was unconstitutional. Section 9 was the part about defunding cities who wouldn't cooperate with ICE. Mm-hmm. Continuing with Judge Orrick, I found that they had pre-enforcement standing, that they were likely to succeed on the merits because Section 9A was unconstitutional, and that they faced irreparable harm absent an injunction. I enjoined Section 9A. The Ninth Circuit affirmed. Here we are again.
Here we are again. It doesn't just say it all, although now we have at least 3 more howler monkeys on the Supreme Court, which we didn't when Judge Orrick made his first order.
Yeah. So once again, Judge Orrick issued a PI, a preliminary injunction, barring the federal government from defunding sanctuary cities, which exercise their right not to cooperate with ICE. Basically the same case.
Yeah, I do wonder if the dogged incompetence of the current Department of Justice might actually help us survive this time. I mean, look, Pam Bondi had this big press conference where she said she was suing Illinois for its sanctuary jurisdiction policy. Apparently, In our view, it's obstruction of justice to refuse to allow local law enforcement to deputize themselves as ICE agents and hold people without a warrant.
Is it now?
No, that's why we have the 10th Amendment. But look, that's the argument that these dipshits are actually making in court. And they just moved for summary judgment in Illinois. I would be extremely surprised if they succeed in that case. So if, and let's be honest, when they lose, they will now have even more bad precedent for them in the funding cases.
Yeah. Can you say more? Spell that out for us?
Yeah, well, look, if your goal is to get the Supreme Court to say that the president can withhold federal funds from the states at will, right, as part of a unitary executive theory, you don't really want to distract the court with the reasons for withholding. I mean, yeah, okay, I understand you're asking, this is a bit of a tortured analogy, but it's like in the employment context, right, where you can fire an at-will employee at any time for any reason, but you can't fire her because she's pregnant or because she's Asian or whatever, right? Like, so here, the Trump administration needs to establish the precedent that it has the unilateral right to cut federal funds at will, that, they're like the at-will employee. That's the whole point of Project 2025, right? To use the threat of withholding federal tax dollars to bully states and law firms and universities and anybody else you don't like into doing stuff that they have no legal obligation to do. That's how you reshape society without having to pass any laws that are staggeringly unpopular, right? But this Illinois suit is likely to establish that the federal government can't demand that local cops help them with immigration detainers absent a federal warrant. So effectively, that's going to put the Trump administration in the position of arguing, hey, we cut funding because the states asserted their rights under the anti-commandeering doctrine. And that's not a great argument to be making in any court. So I think these cases really are at cross purposes for what the right wants to do.
Yeah, I think that's right. That clearly, having a ruling out there that says states don't have to do this and asking them to do it violates the Constitution is going to undercut them in the funding cases. But okay, we have a lot of immigration stuff to talk about.
Yeah, I think this is going to be our new normal. Although, as we've said, the immigration cases are also, they function as a proxy for due process writ large, right? Because if they can take it away from immigrants, they can take it away from any of us.
Yeah, 100%. But before that, let's have one more good piece of news,
all right.
Which is that the Voice of America lives to fight another day. VOA is probably best known to people outside America, maybe better than to Americans ourselves. It was started in 1942 as a means to export American values abroad, back when those values included a free and objectively accurate press. It was a vital tool in the Cold War, which is why all of Trump's dictator friends hate it. Here, conservatives hate it because it's really gold standard accurate journalism subsidized by the government. And by subsidized, I mean Congress allocated $270 million for it. And Trump has been trying to gut it since his first term. He tried to put Justice Clarence Thomas's biographer in charge of it last time around. So there were two pending suits, one in D.C. and one in New York to try and protect VOA. I guess I should say that the New York suit was to protect VOA's parent agency, the U.S. Agency for Global Media, which also includes the Office of Cuba Broadcasting and Radio Free Europe, Radio Free Liberty, Radio Free Asia, Middle East Broadcasting Networks, and the Open Technology Fund. So in March, Judge Paul Etkin in the Southern District of New York issued a TRO barring the Trump administration from disassembling USAGM. He said that the president lacks authority to just shut down an agency created and funded by Congress. And he said it violated the Constitution's Take Care Clause, since the president's job is to carry out the law, not, break it.
Novel.
It violates the separation of powers and the spending clause because Congress gets to allocate the funds and the president doesn't get to just steal them. And it violates the Administrative Procedures Act because obviously it's totally arbitrary and capricious to say just no agency. This agency no longer exists. Also, Judge Etkin did not buy that bullshit, which Trump has tried to sell to all the judges in D.C. about ratcheting down an agency to its minimum statutory function, which is, I guess in some sense is an easier call when it's a radio station than the U.S. Institute of Peace, which makes all of these grants. But reading this, I can't We have seen one judge, Judge Lauren Ali Khan, apply this logic that says, you can't just say we reduce the agency to nothing.
Yeah.
And, that complies with the statutory minimum. I'm sort of surprised more judges haven't said that. But here's what Judge Etkin said. By terminating and threatening to terminate the majority of USAGM staff, canceling grants to its grantee networks abroad, and shutting down the transmitters that serve as the conduits for any radio programming to listeners abroad, defendants have failed to carry out the clear, specific statutory mandates of the agency's governing statute. None of the statutory requirements enumerated above can be effectuated if the agency has been shuttered, and defendants have failed to persuade the court that their actions have been sufficiently narrow in scope such that USAGM is somehow still operational. So there it is. It's hard to tell when a grant-making agency doesn't exist, but if it's a radio show, and it's off the air, you can tell.
Yeah, I agree with all of that, but two things. First, I cannot believe that you neglected to mention that the named defendant in these complaints and the senior advisor to the acting CEO of the U.S. Agency for Global Media is Kari Lake, right? The election-denying loon who helped turn Barry Goldwater's home state blue. And I just have to say, I think it's pretty obvious when you put Kari Lake in charge of anything, you're trying to destroy that thing.
Yeah, no, it's funny because she actually was a local newscaster. But I think maybe if he's not trying to destroy VOA and USAGM, I think what he's trying to do is save Arizona, because every time Kari Lake runs for office, and she runs for office every year, Republicans lose something else.
Keep her busy. It's fair. And second, the parallel suit in D.C., right? You were talking about the New York suit. The parallel suit in D.C. is in front of Judge Royce C. Lamberth, whom you may recall from such films as I'm going to let Larry Klayman and Judicial Watch depose dozens of Clinton White House senior staffers because I'm interested in bullshit conspiracy theories.
I don't know. I think you might be the only one who remembers that.
Anybody who practiced law in D.C. in the 2000s knows that Lamberth was just the enemy of the Clinton White House, right? And
that's true.
And this is the guy who just enjoined the Trump administration from shuttering Voice of America, Radio Free Asia, and the Middle East Broadcasting Network. And this, as you alluded to, Liz, Judge Lamberth's opinion was on the Administrative Procedures Act, arbitrary and capricious standard, right? The Trump administration argued that, it just happened to put every single employee at the Voice of America on administrative leave, so that the USAGM could, real quote, figure out how to best comply with the executive order. And Judge Lamberth was like, what are you talking? He literally said, okay, but then, quote, that necessarily means that the government took the actions at issue here without any reasoned analysis as to what was statutorily required under the executive order and what was not, and the actions taken reflect a hasty, indiscriminate approach. End of real quote. He's right? End of the day, some of our long-standing public networks that have been funded by Congress do live to limp along for another day, thanks in part to one of the most conservative judges in D.C. And I guess kudos to the Trump administration for managing to piss off both Judges Lamberth and, as we've talked about at some length, Judge J. Harvey Wilkinson III on the Fourth Circuit.
Yeah. Oh, and I just want to add, those two cases have now been combined. And usually I would be like, oh, shit, it came from Judge Etkin to Judge Lamberth. But this time I'm like, you know what? It's fine. It's fine.
Yeah,
put those two cases together. He's rolling. Let him go.
Okay, we could keep going ad infinitum. I counted. There were literally 47 new Pacer alerts today alone. There is a Mike Lindell ChatGPT case that I'm dying to talk about. There's the California bar using AI to write bar exam questions. I mean, Liz, you and I could do this show 24/7 and still not cover everything.
Do you know how much I want to talk about Mike Lindell's lawyers getting spanked?
Do you know how much I want to talk about ChatGPT? All right.
Yes. Oh my God, that is where I thought my job was going to be. And now, I mean, I love my job. I absolutely love my job, but it was a little more pleasant when I just got to make fun of Rudy Giuliani all day long.
Let's commit ourselves to doing some fun stories.
Okay, let's catch up on some of these deportation cases. First, for our blog at lawandchaospod.com.
Nice
We
plug.
wrote about, thanks. We wrote about an important development in the Abrego-Garcia litigation in front of Judge Paul Exinas. You may recall that the government basically refused to provide meaningful status updates to Judge Exinas. So she authorized 2 weeks of emergency discovery. Basically, she said, I can't make you bring that guy back, but I can make it really unpleasant for you not to bring that guy back.
Yes.
And then, to no one's surprise, the government just basically refused to comply with discovery. So Judge Exinas entered this blistering order, kind of telling them that something very bad would happen if they didn't. And it looked like the rubber was going to meet the road. And then last night, Judge Exinas entered a 1-week stay of discovery until next Wednesday, April 30th, quote, with the agreement of all parties. And we have no idea what that agreement is. But Abrego Garcia's lawyers at Quinn Emanuel, who are definitely highly, highly aggressive, did not agree to do this for nothing. They got something. I think it's almost certain that they got something, and hopefully that means that Abrego Garcia will soon be on his way back to the U.S. from that Salvadoran hellhole. I guess I would like to know whether the Trump administration is going to stop saying over and over again, he's never coming back, he's never coming back. Like if they dial back the rhetoric.
Yeah, I don't know, but I agree with your read on that situation. And, we should know over the next 6 days. Okay. Next up is one of the JGG spin-off cases. These are challenging Trump's proclamation under the Alien Enemies Act of 1798 that he can just deport anybody that he says is a member of Tren de Aragua because ostensibly they control the government of Venezuela and we're at war with Venezuela. And right. It's just nonsense. Anyway, this case is called J.A.V. versus Trump, and it is in the Southern District of Texas. It is in front of Trump appointee Fernando Rodriguez. And today, Judge Rodriguez granted a temporary restraining order that says, absent emergency injunctive relief, a substantial likelihood exists that the Trump administration will continue to play this shell game, right, of just moving detainees around to different ICE centers when it wants to rendition them to El Salvador, hoping that it will get them into a jurisdiction where their lawyers don't know where they are, and then it can remove them without any due process. If they were to do so, that would take those detainees outside the jurisdiction of the J.A.V. case in the Southern District of Texas because of the Supreme Court's insane ruling that all of these cases have to be brought as habeas corpus petitions.
Right. And I think that there's a couple of really notable things about this. One, clearly the government has burned through the presumption of regularity here. Right. The judges, and I believe that Judge Rodriguez is a Trump appointee, are treating the government like they lie because the government lies, treating it right. It's not a position the Justice Department has ever really been in. And a lot of these cases have been moved to the Northern District of Texas, where there's a judge whose last name is Hendricks.
Yeah, that's the Blue Bonnet facility.
Right. We talked about this on the last show. He refused to issue a habeas. I think he's like the only judge who hasn't issued habeas class certification in these cases. And Judge Rodriguez knows that if he doesn't enjoin taking these, class members, these potential deportees out of the Southern District of Texas, they'll just be shifted to the Northern District of Texas and put on planes.
Yeah. So to do that, Judge Rodriguez did something really clever. He said, I have the power, and he does, it's absolutely clear since the nation's founding, under the All Writs Act, to issue an injunction stopping any party from mooting this court's jurisdiction, right? So once a court acquires jurisdiction, it can issue injunctive relief preventing any party from making that jurisdiction go away. It's not often enforced against the government, but what Judge Rodriguez said was, I am going to enjoin the government with respect to any person that they have labeled as an alien enemy for purposes of the Alien Enemies Act from, and here's the precise language, transferring, relocating, deporting, or removing such person outside the Southern District of Texas, right? So that means not only can these folks not be sent to El Salvador, but they can't be sent to Boise or South Bend or as you point out, Liz, the Northern District of Texas or whatever other ICE facility the administration would like to house them in next.
Yeah. Also in this case, Judge Rodriguez unsealed this declaration that the government has been trying to keep under wraps. And you can see why it's been trying to keep it under wraps, because this answers a question that has been asked in a whole bunch of courts. The declaration was by Carlos Cisneros, an assistant field office director at the ICE facility in Harlingen, Texas, where they have held a lot of these detainees. And in fact, I believe that's where the original planes took off during that hearing before Judge Boasberg. So Cisneros said that the notice of deportation, which is given to these potential deportees, is read in English, but he pinky promises that they have Spanish language interpreters who explain it to them. Cisneros said they do not tell the detainees that they have a right to file a habeas claim to challenge their deportation, but they do allow them to make a phone call. And he said that if the detainees don't file a habeas petition within 12 hours, they begin deportation arrangements.
12 hours? I mean, look, even this Supreme Court cannot possibly think that that is a reasonable amount of time to file a habeas petition to challenge deportation to a foreign gulag. I mean, it is no surprise to me that Judge Rodriguez was like, hell no, not on my watch.
Right. And this is information which has been filed in all of these other cases, right? Because this is a question which the Justice Department, on behalf of DHS, has tried very, very hard not to answer, because they know that if they say, well, we're giving them 12 hours and we don't tell them that they can file habeas and the petition is only in English, like, no court is going to say that that is sufficient under the Supreme Court's instruction to give these people a reasonable amount of time and space to make the challenge.
Yeah, a reasonable amount of time means 2 weeks to 30 days, right? Like that's what any court is going to say.
Yeah, I believe that we talked a couple of days about, I think it was the court in Boston imposed a 15 days, something like that. But we're not talking, 12 hours is not it. Okay, we're going to talk about this more in detail next week. But there's also another Trump appointee, Judge Stephanie Gallagher here in Maryland, who ordered the Justice Department to bring another guy sort of similarly situated to Abrego Garcia back from CICAD in El Salvador to facilitate his return.
Yeah, 3 things. 1, Judge Gallagher does, or at least did, identify as a Republican, but I should point out in fairness that she was first nominated to the bench in Maryland by President Obama, was blocked by Mitch McConnell because he blocked all of Obama's judicial nominees, even the Republicans. But she was then renominated by Trump and confirmed in Trump's first term in 2019. She is, I think it's fair to say, the least Trumpy Trump appointee anywhere in the country. 2, Judge Gallagher's order explicitly cites to Judge Exenis's order in Abrego Garcia with respect to that facilitate language that you've used. And I think, we've talked about when, when Judge Amy Berman Jackson was the first judge to issue an administrative stay at the district court level against the Trump administration, and then 24 of them did it, right? Like I think the floodgates are about to burst on that one. At least I hope so. And third, this case is super interesting procedurally, right? Because what the Trump administration has done here is violate a 2019 settlement agreement about how they were going to treat certain detainees. And I think that really helps to illustrate that what the Trump administration wants here is an outcome, right? They want these people out of this country, and they do not care how many laws they have to violate to get there.
Yeah, I mean, just not to put too fine a point on it, this case is really, in some sense, quite similar to the Abrego Garcia case, because Abrego Garcia and the pseudonymous plaintiff in this case, I think that they just refer to him as Christian. He's a member of a class, but that both of them had orders that said, you cannot remove this person. And what the government's counter is, well, Abrego Garcia, he's a gang member, and so the judicial order that bars his removal to El Salvador, it just doesn't count now because we've said he's in a gang, and that's what they said here. That the executive order, by speaking it into existence, he vanishes 2 court orders that said that he couldn't deport these guys to El Salvador. I mean, the implications, if he can get away with this, are really staggering, because what he's saying is, I don't care what courts say, and I don't care what the law is. If I say that you're unpersoned, I can deport you at will. I mean, that's terrifying. Okay, we're going to take another ad break. We will be right back.
And we're back. Okay, so Liz and I arm wrestled during the ad break, and she's letting me do a deeper dive.
Yeah, I won, so I could stop monitoring Pacer for 12 more stories.
Is that how it went down? Oh, okay. All right. Fair.
Don't make me come over there.
All right. So this is an update on a Massachusetts deportation case that we talked about on Tuesday because holy shit, did this one take a turn for the crazy. The case is captioned D.V.D. versus Department of Homeland Security. This is the one where Judge Brian Murphy enjoined the government from renditioning immigrants to third countries without notice or a means to contest when they cannot be sent to their country of origin.
Yeah, I think that was the one where the order was 15 hours. But the Justice Department has obviously appealed to the First Circuit already.
Yeah.
Just as a side note, I think this policy of appealing every goddamn TRO and administrative stay like immediately and taking it all the way to the Supreme Court, it's like, I think it's starting to backfire. Like the Supreme Court is not interested. I mean, they'll do their shadow docket thing, but I don't think they're interested in spending the summer being like the emergency review panel for every TRO. Pam, looking at you.
Yeah. Justice Thomas has got the open roads that he needs to explore on that RV of his. But
Stupid RV.
Okay. As background for this case, sometimes people come to this country illegally out of desperation, right? Because they are at legitimate and real risk of being tortured and killed if they stay where they are. They come here and they file for asylum, which is a humanitarian kindness that our country used to believe in. And it happens to accord with international law, treaty obligations that we have signed. That's nice. But asylum claims can take years to process. And so during the first time around, his first administration, President Trump issued a bunch of rules and directives, making it much harder to qualify for asylum. And a lot of that was really cynically exploited during the ongoing coronavirus emergency, right? And this was at a time when, Trump was publicly saying, there's no emergency. Why don't you all go cough in each other's faces and snort some horse dewormer?
And yet the southern border's closed because of coronavirus.
Right. So anyway, the point is, while your asylum claims are pending, and they can take years, the government can try and deport you back to your country of origin. But if an immigration judge determines that you, as the asylee or asylum seeker, are at risk of being tortured or killed in the country to which you would be deported, they can issue an order withholding removal that would prevent the government from sending you back there because that would violate the Convention Against Torture, which we have ratified.
Right, which is how Kilmar Abrego Garcia got an order withholding his removal to El Salvador. The judge said he made a credible claim that he'd be killed by gangs trying to extort his family. And so, as with Abrego Garcia, the typical practice of ICE up until now has been to release from custody anyone who is subject to those withholding orders if they're not otherwise dangerous. It's called the non-detained docket. And the legal standard is whether there is no significant likelihood of removal in the reasonably foreseeable future, which makes sense, right? Because if the government isn't going to deport you anytime soon, because, that would violate the Convention Against Torture and you're no danger to the community, the sensible thing to do is put you on a sort of probationary release. And if conditions change or if you commit a crime or whatever, you become dangerous, the government can take you back into custody. And of course, everyone on the non-detained docket still has to check in regularly with ICE, and failure to check in results in being redetained. But this is what the right wing doesn't like. They call this catch and release and try and pretend that it's like releasing people and never keeping track of them again.
Yeah, that's a lie. And that explains an internal memorandum issued on February 18th by Trump's Department of Immigration that got leaked to the press. That memo says, in relevant part, withholding of removal under the regulations implementing the Convention Against Torture is a country-specific protection from removal. Accordingly, when an alien granted such protection reports on the non-detained docket, enforcement and removal officers should review the case to determine the viability of removal to a third country and accordingly whether the alien should be re-detained.
Yeah, that's the Trump administration saying that if they can't deport someone because that person would be tortured and they're on the non-detained docket, ICE officers should actively look into whether these asylum seekers can be taken back into custody and then sent to some third country instead. Not that the third country is necessarily safe, just that there hasn't yet been an adverse determination by an immigration judge that the third country also presents a risk.
Yeah, and that's why the DHS ghouls have been making deals to rent prison space from friendly despots, right? Because they do not want people awaiting asylum from being tortured to stay in this country, even though those people are obeying the law and checking in and paying taxes. No, they want them the hell out.
Yeah, and they don't want to provide them with any process at all. That's why the Trump keeps whining on social media about how impossible it is to give these people a trial and lying about how they're all like gangsters and killers and human traffickers. Because what he really wants is just like pick up everyone who doesn't have U.S. citizenship and rendition them without process to some foreign hellhole. And he knows if he just said like, well, this guy's a normal dad working a job, like paying taxes, raising his kids, but we, got to fill these buses and deport people, and that's our plan. Like it would look even more lawless than it does now. So he has to say, these are terrible gang members, whatever. Yeah. But of course, that's totally lawless, which is what more or less every court has said.
Yeah, and that takes us to D.V.D. versus Department of Homeland Security, which is analogous to the Abrego Garcia case in that the government keeps trying to say that Trump's executive orders or determinations that a particular immigrant is a member of MS-13 or Tren de Aragua, and that puts them outside of the law. So in the case of Abrego Garcia, the government first admitted that he had been wrongfully deported, and they called it an accident. Now they're saying that the immigration judge's order was somehow canceled out by Homeland Security, saying that the poor guy's a member of MS-13, which he very clearly isn't. But even if he was, the order by the immigration judge would still be operative. And even if there was never an order, he would still be entitled to due process. I mean, like, the government's theory in all of these cases is that the president could just magically remove all of the protections of American law from a human being via executive order, and he cannot.
No, he can't. Okay, so the plaintiff here is D.V.D. Obviously, those are his initials. He's a citizen of Cuba who is married to a U.S. citizen. He has 2 children who are also U.S. citizens. In 2017, an immigration judge issued an order of final removal, designating Cuba as the only country to which he could be removed, to where we could send him.
Right, and that's because U.S. immigration law does not allow the executive branch to just dump human beings anywhere on the planet, right? Instead, someone who is here outside of legal status, where they can be sent is governed by 8 U.S.C. Section 1231. And in general, that's the language of the statute, that means the country in which the alien boarded the vessel or aircraft on which the alien arrived in the United States. So if you came here via boat from Cuba, you can be deported back to Cuba. But you might be thinking, what if somebody is from Cuba, but they take a boat to Mexico and then they transfer to a truck and then they cross the border from Mexico into the United States? Does that person, when deported, get sent back to Mexico? And the answer obviously is no, right? The next section of 1231 covers that. It says if you boarded a vessel in a country or territory contiguous or adjacent to the United States and you're not a citizen of that country, the government sends you back to the country in which you took the first vessel, right? So again, Cuba. So far, so good.
Right, that makes sense.
Yeah. And then the law has, as most laws do, a catch-all provision, right? Because it's possible that someone boarded that initial vessel to the United States from a country that will not accept their summary return. Sometimes those nations flat out refuse. Sometimes they require additional procedures. They're called recalcitrant countries, and they include, in Latin America, Venezuela, Brazil, Nicaragua, and Cuba.
Yeah, sidebar Cuba. Remember our buddy Aaron Reichlin-Melnick, who was on a couple of weeks ago? Yeah. He has called that the prototypical recalcitrant country from the 1960s until today. In 2017, in the waning days of the Obama administration, the U.S. reached a deal with Cuba to restart deportations, which the Trump administration promptly repudiated because we can't have anything that Obama ever did.
Yeah, make America great again. So, okay, if and only if the country you came here from is recalcitrant and will not accept you back, then the government can remove you to any of the following countries: the country of which you are a citizen, the country in which you were born, or the country in which you have a residence. But, we're doing all the edge cases. You might be asking, what if none of those countries will take you back either?
What if, Andrew?
Yeah.
What if none of those countries will take you back?
Well, in that case, we have now delved down to 8 U.S.C. Section 1231, B1, subsection C, subsection 4. And that says that if removal would be, and the language is impracticable, inadvisable, or impossible, nice alliteration, then and only then the person can be deported to, quote, a country with a government that will accept the alien.
And that space, the exception to the exception to the exception, that's where the Trump administration wants to live, right? There's a lot more to the statute. That it includes allowing a person to be deported to designate the country of return. But the bottom line is that the law passed by Congress said, we return immigrants subject to a final order of removal to a place that they came from or a place where they're a citizen. And if that's not possible, the very last resort is somewhere that will take them, which brings us back to D.V.D., or it will in a moment, after this brief ad break. And we are back. Okay, so D.V.D., the plaintiff in this case, had an order of removal to Cuba. But Cuba wasn't going to take him back, so D.V.D. was placed on the non-removal docket in 2017. And because he was on the non-removal docket, D.V.D. was required to check in regularly with ICE, typically once a year, and usually via telephone or email. He completed his last check-in on Friday, March 7th, 2025. And then, 3 days later, something weird happened, which was that ICE sent a letter to D.V.D.'s lawyer saying that he needed to report for another check-in in person in Burlington, Vermont on March 28th. And the lawyer said, that seems weird since we just had our yearly check-in. So he asked ICE why, and he got an email saying that ICE was requiring all people to report in person and more frequently on a case-by-case basis.
Yeah, to which D.V.D.'s lawyer said, well, I've been an immigration lawyer for decades across a bunch of administrations, and I've never, ever heard of ICE calling someone back for an in-person check-in 3 weeks after their regular annual check-in. So the lawyer inferred that this was probably a lie, and that the government was looking to implement that February 18th memo that we discussed. And that meant getting D.V.D. to show up somewhere in person so they could physically take him into custody, send him off to one of these ICE camps, and then rendition him to a third country, meaning El Salvador.
Which, by the way, is exactly what the Trump administration was planning. They don't dispute it in this case, and they have indeed been scooping up immigrants at these routine appointments and summarily deporting them. Like, not immigrants who have broken the law, just like, oh, you're here for your regular check-in? Well, here, now we're going to shackle you and, send you off to a gulag.
Right. So D.V.D.'s lawyer brings the case. It gets assigned to Judge Murphy. He issues a temporary restraining order within a couple of days on March 28th. That prohibited the defendants from removing D.V.D. or any of the named plaintiffs, and then also issued a nationwide injunction preventing the defendants, and you'll see the reason why I keep using that word in a minute, from, and here's what they could not do, removing any individual subject to a final order of removal from the United States to a third country, i.e., a country other than the country designated for removal in immigration proceedings, unless and until defendants provide that individual and their respective immigration counsel, if any, with written notice of the third country to where they may be removed, and until defendants provide a meaningful opportunity for that individual to submit an application under the Convention Against Torture for protection to the immigration court, and if any such application is filed, until that individual receives a final agency decision on such application.
Okay. So that TRO was entered on a Friday afternoon. And on Monday morning, March 31st, Secretary of State Marco Rubio once again took to Twitter to boast that the administration had sent 17 more people to El Salvador over the weekend. And unless all of those 17 people had removal orders to El Salvador, that would seem to be an admission that the government had just violated Judge Murphy's TRO. And in fact, the plaintiff's lawyers say they have evidence that at least one of the people deported was to be returned to Venezuela. So the lawyers emailed the government and asked them to confirm whether they had complied with the court's TRO. And after a couple of days, they got a response from DOJ lawyer Mary Larrickers that the government, quote, has no information to share at this time, which does not sound like, oh, it's fine, we totally complied with the court's TRO.
No, it does not. So at the preliminary injunction hearing that was already scheduled a couple of days later on April 10th, Judge Murphy also asked that question, right? Asked the government whether it complied with his order, and he got the usual hemming and hawing. So in addition to granting the preliminary injunction that day, which he did, Judge Murphy also ordered the plaintiffs to provide names and alien numbers to the government by the next day. And the plaintiffs identified 6 people of those 17 that Marco Rubio bragged about who appeared to have removal orders to somewhere other than El Salvador, and they sent their names and alien numbers to the government. That information is, of course, redacted in the public filings. And Judge Murphy said, okay, DOJ, you got the names and numbers. Now you have 12 days. You have until April 23rd to explain how sending these people whose removal orders said some country other than El Salvador to El Salvador. Because, remember that injunction said no renditions to any third countries without notice and an opportunity to contest. That response came in yesterday as we record this, and holy shit, is this shockingly mendacious even for the Trump administration.
Right. So here's what the government said. They admitted that all 6 of the people identified by the plaintiffs were in fact removable to somewhere other than El Salvador, but they got sent to El Salvador anyway. So on its face, that violates the court's TRO. But the administration says, no, it's fine. We actually followed the law. So here's how they slice that salami. For 2 of the detainees who were removed, each of whom were supposed to be removed to Mexico, but were in fact sent to El Salvador, they said, no, we sent these guys out on the morning of March 28th, a couple of hours before the court entered the TRO later that afternoon. So, I guess they're technically correct, but I don't think that's going to really cut the mustard.
Yeah, and that's if they are to be believed. Like I don't
which nobody does anymore. As we said, exactly. Not even federal judges are believing the DOJ at this point.
Right, but at their best, that would look to be a pretty flagrant effort to try and evade an order that is forthcoming, and that already infuriated the Fourth Circuit in the Abrego Garcia case.
Yeah, and in the JGG case.
Yeah,
but it gets worse because the other 4 detainees, here's what the government says happened. Redacted, that's the name of one of these detainees, was removed to El Salvador on March 31st by the Department of Defense on a flight where no Department of Homeland Security personnel were on board. Homeland Security did not direct the Department of Defense to remove the redacted person. The Department of Defense is not a defendant in this action. So it's hard to kind of follow it, but the argument here is that the court's TRO only applied to the named defendants, which is DHS, Secretary Kristi Noem, and Pam Bondi, the Attorney General, and also the superintendent of the Plymouth County Correctional Facility, where one of the named plaintiffs is being held. They're saying, well, if the Department of Defense came and took these guys, what were we supposed to do about it? Obviously, it didn't violate the court's TRO for the DOD to send those 4 men to El Salvador after the court specifically said, do not do it.
Yeah. And so when I read that, I was like, wait a minute. Why is the Department of Defense deporting people at all, right? Like the reason they're not a named defendant in this lawsuit is because that's not their job, right? Like that's not what the Defense Department does. And to figure out why it's the Department of Defense who's acting here, you have to dig into the supporting affidavit that the government filed. It's from Tracy Huddle. She is a 20-year veteran at ICE. She is currently the unit chief for field operations, domestic operations for the Southwest region. 7 states report to her. And here's what she says happened. So remember, court issues the TRO in the afternoon of March 28th on a Friday. She then says, on Saturday, March 29th, the day after that TRO gets issued, those 4 men were sent by Homeland Security, a named defendant, right, unequivocally subject to the order, to Camp 6 at U.S. Naval Station Guantanamo Bay in Guantanamo Bay, Cuba.
Jesus Christ. I know that the original sin of America is slavery, but honest to God, Gitmo is the original sin of the 21st century. Like, this is what happens when you create a law-free zone to disappear people into because you don't like them and you don't want the law to apply to them, right? That is where everything went sideways maybe before that, but that is where this came from. Like,
that was a Rubicon that we crossed.
Right, 100%. Once you go down this road, it doesn't stop.
Yeah. So they're sent to Gitmo on March 29. And then on March 31st, 2 days later, the Department of Defense, which administers Gitmo, sent them to El Salvador, supposedly not at the direction of Homeland Security. Although,
Sure.
I would be remiss if I didn't point out that President Obama ordered the return of nearly 200 detainees. He ordered them released from that same Camp 6 back in 2012. And Republicans in Congress have been holding that order up for more than a decade. But somehow these 4 people and possibly others were processed in and out of Guantanamo Bay in 48 hours. I mean, someone gave direction and we will find out who. But look, even if this were just a blind eye, like, nobody coordinated anything, like, it nevertheless violates Judge Murphy's order because that order applied to all of the defendants, including Homeland Security, and, quote, all of their officers, agents, servants, employees, attorneys, successors, assigns, and persons acting in concert or participation with them. So, in other words, if the Department of Defense cooperated at all in any way with Homeland Security in connection with sending these 4 men onto El Salvador, they deliberately violated the TRO, right? Like, it's not just at the direction of it. If there was any phone call, any document, any direction, anybody spent 8 seconds on the tarmac together, right? That violates the TRO. And so, again, to close the loop here, all that this case is about is whether the government has to give notice before sending you off to a third country that is not your country of removal. And this administration is fighting that tooth and nail. They are breaking the law because they think they can.
Yeah. And so far, the courts are holding, at least the trial courts. I think that this is such flagrant bad faith. Mm-hmm. That I do think, we saw the Supreme Court last week in that emergency order say, like, cut the shit, stop. You have got to give these people a real opportunity to challenge this deportation.
Yeah.
I don't have a lot of confidence in the Supreme Court writ large, but I do think the Trump administration's flagrant defiance of the judiciary writ large, I don't think that will play with the Supreme Court.
I hope you're right. You might be, but all we can do is keep monitoring and reporting, and that's what we'll do.
All right. That is going to do it for us this week. Thank you guys for hanging out with us. Thank you for supporting the show. If you like it, I would really appreciate it if you would go and give us a 5-star review on your platform of choice. And have a lovely weekend. Go outside, enjoy the spring. Thanks, guys.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Ipsa Media, LLC, all rights reserved.